Welcome to Global Investment Voice, your premier podcast for diving deep into the world of investment migration. Are you dreaming of a second or third passport? Then join us as we traverse the globe, exploring the ins and outs of the US EB-5 immigrant investor visa, uncover the secrets of golden visas, and delve into the many residency and citizenship by investment programs. Each episode is packed with exclusive insights from top industry experts. Whether you're an investor, developer, or a visionary entrepreneur, we're here to guide you through the complexities of global investment migration. And who better to navigate this journey with than your hosts, the dynamic legal duo of this industry, Mona Shah and Rebecca Singh. Plus, hear directly from a lineup of global investment migration leaders. So, buckle up and tune in to Global Investment Voice, where your global investment journey begins and expands.
Welcome back to Global Investment Voice. Over the Memorial Day weekend, a single USCIS policy memo set off a wave of panic across the US immigration world. And I can tell you, we've had headlines from New York Times, NBC, Guardian, you name it. Immigrants are in a panic, and there's a lot of discussions going on. And we would like here on Global Investment Voice, we do try to cover all aspects of investment immigration, and this really is pertinent. Well, today we would like to cut through all of the noise that is out there. And I am joined by my colleague, Abdul, and his assistant, Doris Chakra. Welcome to Immigration Voice.
Hey, good morning, Mona. Thank you for inviting us.
Good morning. It's good to be here.
Well, with all of that's what's going on out there, it's good to hear another viewpoint. And I know you are exceptionally well versed in this area, Arif. But let's just start and lay it out a little bit for our listeners who really aren't quite sure. So it happens that there is a way, if you come into the United States and you're working over there on say, a different visa, that you can actually adjust your status and you don't have to go out. And Doris, what did this memo actually say? Because obviously it is related to that ability to adjust.
Mona, prior to this memo coming out, eligibility was typically treated as sufficient for approval. What this memo is saying is that eligibility is no longer enough, and meeting the requirement does not guarantee approval. It changes the posture, not the law.
Oh my goodness. So in plain English, Arif, it's basically saying, right, that no one can adjust and everyone has to go to the consulate. And we all know what kind of nightmare the consulates are.
Indeed. So essentially, as Doris said, it changes the posture, gives the officer more discretion, and adds a layer of uncertainty that shouldn't be there.
Right. Well, we obviously are not going to talk about all of the areas. Of course, you can mention certain areas. I'm pretty sure this topic is going to come up over and over again. But Arif, EB-5 is a little different, right?
Indeed it is, because the explicit command to allow adjustment inside the U.S. is baked into the law of RIA, which is Reform and Integrity Act of 2022.
That's right. So back in 2022, there was the latest piece of legislation which covered EB-5, right?
That is correct. The central message and the core assertion is really Memo. It reminds the officers that adjustment of status is a matter of discretion. But guess what? It always has been a matter of discretion anyway. It's not, the outcomes has never been guaranteed. It's not guaranteed. Now it was never guaranteed.
You know, you're right. I've done cases, I'm talking about back like 20 years ago, Arif, where maybe it was an asylee and they were trying to adjust, and an officer could turn around and say, the officer didn't have the right to kick the person out, but he had the right to say, look, I think you're a waste of space and I'm not going to agree to you having a green card. I mean, that happened then. This is not a new policy.
Indeed, it's not. The fear that it is created has given an undue impression that all is lost when it is not. It's just a layer that they have added and asserted in writing, which already was there.
Doris, but what do you think of the timing, the day before a major national holiday, when we know how many people are even around on that Friday? Most people have already taken off.
Honestly, we've seen this happen in the past where the USCIS does this right before longer weekend. obviously creates chaos and fear amongst people. And typically they clarify on it within the next couple of weeks. Right now, obviously, we don't actually have much clarification on this. What we're doing so far is trying to analyze what we have of the memo so far, but we should have more clarity in the next couple of weeks.
Yeah, I hope so. But even before we get to that clarity, Arif, because you're very well versed in EB5, I know. And what else do you practice other than the EB5?
Yeah, so a little bit of background, Mona. I won't bore you. I did my JD and LLM in Miami, and my focus back then was to be a specialist in anti-money laundering and doing white-collar crime. And then it didn't work out quite the way I envisioned. So I ended up doing EB5 investment and basically...
I'm not going to laugh about the correlation between the two. Sorry.
I can assure you, there's plenty of correlation there. So this area came natural to me, especially the financial part came naturally to me. So it helped me, the financial background helped with the EB5. I've been doing EB5 since 2018, relatively new to this world, but not new at all to money laundering and financial crime. We've had an enormous amount of phone calls by H-1B persons who are transitioning over to EB-5.
I think we should emphasize that this podcast is related to EB-5 and not necessarily if you were filing an EB-1 or an EB-2. I mean, that is the area when Doris, you mentioned we need clarification. I feel like the industry in EB-5, and correct me if I'm wrong, have rallied around the fact that, yes, Arif, you're right, it's baked in. The provision for adjustment of status for somebody who's filing for EB-5 is baked into the law.
Yeah.
That's exactly right. It's baked into the law. All other forms, there's a statutory right anyway, but it's not as nearly as strong as for EB-5 under the Reform and Integrity Act of 2022. Yeah, obviously, without trying to be too dry, Section 245N is where our hook is, where it allows us to do. But then again, as you and we discussed earlier, the matter of discretion to approve a 485 has always been there. This is nothing new.
Right. But here's my question to you. I mean, you do an awful lot of deportation hearings as well, and especially in relation to this particular area. Can a policy memo, now this is all what we have right now, can a policy memo, or even if this goes into a regulation, can it override a statute?
Absolutely not. Of the policy memo, it's just a policy memo and a guideline. It is nowhere near has any legal authority. Congress writes the law and the agency writes the regs to carry them out. And below that is a policy memo. Basically, a policy memo, Mona, as you know, is simply telling the agency it's how its own officers how to think. That's really the essence of it.
But here's the other side of it, the coin. A policy memo plus a discretionary, with this command, so to speak, to really be discretionary, it is going to change the way that EB-5 lawyers put in an adjustment of status application. We've been doing this for many, many, many years. And we know that, adjustment of status is not something which is connected necessarily to how you get your green card. So if you got your green card because you've got extraordinary ability, or you're a big business person, or maybe you're an amazing cook, the adjustment of status, they don't look at that, right, Doris?
No, they do not.
Yeah.
But see, this is where it becomes a little hairy. This policy memo talks about officer can grant a waiver for extraordinary circumstances. And it doesn't tell what extraordinary circumstances are. So we're kind of scratching our heads, define extraordinary circumstances. Is it the economic impact of 800,000 or $1 million warrant a finding of extraordinary circumstances? We don't know that, do we?
No, we don't. And honestly, it's going to be, I mean, I think personally, give me your opinion, but it's going to be dependent on the officer as to what he thinks. Yeah. I know that one thing, they are scared of the EB5 crowd because we're the ones who start the litigation.
Exactly. I was going to say that that's the nice thing about EB5. There are so many protections at so many stages of the process, too. And when things go wrong, we can always litigate.
Yeah. Yeah,
Right.
correct. And also, I have seen in counselor processing interviews, the EB5 candidate is treated with kid gloves because they know these people have money, they have resources to really not take a simple yes or no and go home.
Good point. Mm.
Yeah. I mean, obviously, no, I don't have any empirical evidence to prove my point, but just a general observation, these guys are treated differently.
You know what my fear is, though, is that the people who are from the countries which are on the so-called soft travel bans. So if you're already in this country, say you're from Bangladesh or Pakistan or one of those countries, and you're in this country legally on an L1 visa or a F1 visa, I don't think it's going to be as easy anymore to be able to adjust.
I absolutely 100% agree with that because that is the stated, that is not even a dog whistle. It's a four-alarm fire. They clearly are saying they do not want immigration from these countries, period.
Arguably, it was already pretty difficult for them to adjust within the US. What we've seen in our practice actually is a lot of those people already had scheduled interviews that were paused, canceled, etc. So they were already under a lot of heat, and this memo just makes things that much more difficult for them.
Well, I have another question for you, Abdul Arif. I was reading some of the blogs which have come out, and I think people are not really understanding what 245N actually is. It's like been thrown around. I mean, it's something obviously which protects the filing, but I have seen stuff out there which says, oh, if you do EB5, your green card is guaranteed and you can relax. That's not true, is it?
Absolutely not. There's nothing guaranteed. In any attorney that tells you an EB5 is guaranteed, please run away from that attorney. No attorney should be able to guarantee anything. All we can guarantee is our best efforts. And in full disclosure, disclose to the client where the risk factors for approval are. That's all we can do ethically, morally, and rightfully so. We inform them. So, again, coming back to this, Mona, EB5 protection is not that the discretion disappears.
Right.
The Congress has taken two specific things off the table for the better. The INA 245N removes the discretion whether a concurrent filing can happen. And the Section 245K says even if you have 180 days of past status problem, the discretion still survives. I don't want our potential applicants to relax saying that. The only thing we can say is if compared to other forms of adjustment of status, in other words, legal pathways to green card, far and away, EB5 is still the better options. Not by any means guaranteed, but it's if I had a choice of feeling good about an H1B guy versus EB5 guy, I would pick the EB5 guy anyway.
Yeah, I hear you. I do think the memo is open for, it's really set up for like a textbook arbitrary and capricious kind of challenge. But at this point, what we are seeing from our clients is what do we do when we're doing our adjustment of status? Do we just file as the same? Do we have to file extra? Do we have to have like background checks? Do we have to put a whole resume? So what are you advising clients who you are going to file their adjustment, say tomorrow or next week, now that this memo's there?
Yes. So, as you say, because the word shall in 245N is mandatory, not optional. So, each EB5 application that is concurrently filed shall be considered to be properly filed. USCIS does not get to decide whether the filing is counts or not. Congress has already said it is.
So you're saying, Arif, that an officer cannot reject an EB-5 concurrent filing as improperly filed?
Absolutely not.
Okay, yeah.
He can always find other reasons. If he doesn't like what he doesn't like, he can always reject that. But he certainly cannot not accept it.
Okay, so here's one other quick point I would like to ask you. There is a provision in the same provision, it's the 245K, which forgives a certain amount of days that you perhaps overstayed. And it often happens with our clients when they come in for EB5 and they want to adjust in the United States. And for one reason or the other, they might be at 10 days, 2 weeks or something as an overstay. Right now, do you believe that with this new memo that USCIS are just going to ignore this ability to forgive under 245K?
They better not, because it's baked in the law. They cannot ignore that. There's nothing in this memo that speaks to 245K, which is forgiving of the grace period. In other words, the applicant does not accumulate unlawful presence. In other words, his permitted stay continues in these 60 days. So we're safe as far as that is concerned, as far as this part.
Yeah, I can tell you one thing, though. I don't know if you have a comment on this, that because we work a lot with our global programs and colleagues overseas, this memo was a gift, absolute gift to them. They have gone crazy with the blogs that, oh, you don't want to go to the US. It's so uncertain. Anything that's marked with grace is uncertain. It's working. For the first time ever, there have been more people leaving the US than coming in.
And that's unfortunate, but that's a kind of a policy, political question. We will leave it to those experts. You and I want to see how we can use this latest memo to help understand, not necessarily create some kind of fear, but to assuage the fear. And then encourage clients to apply now before, especially from India and China, so the policy, the visa availability does not retrogress.
Right. So really a good takeaway from all of this, Arif and Doris, is don't panic. You have the right to file an adjustment. You don't have to rely on a consulate, because that panics a lot of people. We all know how arbitrary consulates are. And if you get an RFE, again, that's not something to panic. But do you have any takeaways for people to perhaps prepare beforehand?
See, already our EB5 applicants prepare already so much. I cannot think of anything additional to prepare until there was an RFE issued, because RFEs are often arbitrary. Often they ask for the same things over and over after being provided. So I cannot think of anything extra other than to be fully aware of what we are talking about, that the filings can happen. It's a matter of discretion is still alive, and not to panic.
If I could leave investors with one line, honestly, it would be that the statute did not change and the EB5 right to file is still intact. I don't think they should panic. A well-built file with a good counsel is the right response to this.
Right. Arif, this came out just before Memorial Day weekend, and it came out in such a way it was designed to panic. Why? Do you have any thought? Why do you think?
You know fully well, Mona, because it's the policy directive of the White House Deputy Counsel Miller, and who absolutely does not want any illegal immigration. And that's designed, as you know, major negative news coming out of Washington is always on a Friday night.
Yeah.
So that to create the maximum impact and panic, because the weekend is there, the holiday is there, people are scrambling. It's working exactly like it was designed to release late Friday afternoon to have the maximum negative impact.
It did. It absolutely did. I mean, we've been so busy on this holiday weekend. It was like, leave me alone.
Exactly right. But Mona, you're a happy warrior. You have been a happy warrior in this arena. And in fact, you've been a gladiator. Let me put it that way. And I'm happy to join the ranks of being a gladiator in the arena. and these two shall pass and we will prevail. The court of law is always the option, right? If
Right.
you know fully well there's somebody somewhere out there preparing a complaint, and he's probably looking for plaintiffs.
That's right. It's probably already started.
But see, just FYI, putting my lawyer hat back on, the injury is not mature yet. In other words, no one has been harmed yet. So I don't know if it might be too early to file a lawsuit, but I leave that to the litigation bar of AILA to see when the appropriate time. And I'm sure you and I will be watching closely.
Oh, yes. Watching and recording and for our audience, bringing you the latest. In fact, I think it would probably be a good idea to come back and see how this is actually working, because I presume that this is an immediate call to action by USCIS, and perhaps something to do with all of the delays that people are seeing in the adjudication right now.
That is so true. See, it always is a little bit refreshing, Mona, because what I considered are the big elite firms on the East Coast, but there's a lot happening in the Midwest too. I just want you to know that.
Other than ranching?
Other than ranching.
Arif, it's a pleasure having you and Doris on, and we welcome you back to speak more on all of these topics. Thank you for coming on Global Investment Voice.
Thank you for having us.
Thank you for having us.
And that's a wrap on today's episode of Global Investment Voice. A huge thank you to all our listeners for tuning in and sharing this journey with us. Curious about unlocking the potential of global migration and citizenship? Make sure to visit us online at mshalaw.com and globalinvestmentvoice.com. Dive into our extensive library of podcast episodes. Stay ahead with the latest in migration news by signing up for our insider newsletter. Don't forget to connect with us on social media. Find us on LinkedIn, Instagram, and Facebook to keep the conversation going. Remember, the insights shared in our podcast are for informational purposes only, so please seek tailored legal, financial, or investment advice where needed. Thanks again for listening, and until next time, keep investing smart and living well with Global Investment Voice. We'll see you on the next episode.